And I'm going to turn it over to our judges.
Hello, West Virginia. Thanks for being here and congratulations on making it to the national finals. My name is Johnston. I am an attorney in New York City, joining you from my apartment in Manhattan. And when I was in high school at your age in Indiana, I was a We the People participant. So I kind of know what it's like to be on your side, though I never did it on Zoom. Best of luck today. I will have my fellow judges introduce themselves next, please.
Good afternoon, West Virginia. I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington. And congratulations on making it to the Nationals. And I look forward to hearing your presentation.
And I am Edward Volpe. I'm an attorney from Denver, Colorado. I've been working with this program for many, many years. I know how hard you had to work to get to this point of being in the national finals. I congratulate you upon your success, and I look forward to hearing from you.
Would you please introduce yourselves and your teacher?
I am Tamara Singleton.
I am Sophie Brager.
And I'm Andrew Davis, and we're representing Unit 5 for Mr. Phillips' AP Government and Politics class at Robert C. Byrd High School. And our teacher with us today is our Assistant Principal, Mrs. Looker.
Very good. All right, let's get started. I believe you know we're doing question 2 today, so I will read it all the way through. When I stop talking, you can begin and that'll start your time, okay? A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on interference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? What are the differences between positive and negative rights, and which are more important to the preservation of liberty? You may begin.
When Thomas Jefferson stated this quote, he was addressing in reality that the Bill of Rights protects the citizens from the government misusing their power. The Bill of Rights doesn't give us, the people, the right of freedom of speech, religion, etc. It just puts a restriction and a chokehold on the government not to infringe on those rights. So this better explains and connects the reasoning behind Jefferson's statement on the Bill of Rights' purpose and entitlement to the people. The interpretations and application of the Bill of Rights is what gives limitations their importance and controversial arguments. I agree with Jefferson in the sense that the government does need to be in check with their power by the people who supply it. But in another way, I do not agree with the practice of writing down what is already known to be our quote-unquote God-given rights.
A national Bill of Rights applies to every U.S. citizen in a broader sense, specifying fundamental human rights most people assume are given. A Bill of Rights gives further legal protection to minorities who otherwise could be exploited in individual states. The Supreme Court case Roe versus Wade protects a pregnant woman's liberty to choose to have an abortion without excessive government restriction. Prior to Roe versus Wade, 30 states have made abortions illegal. A state law that broadly prohibits abortions without respect to the stage of pregnancy or other interests violates that right today. Even though the Constitution doesn't specifically cover abortions using the due process clause of the 14th Amendment, the right to privacy protects a pregnant woman's choice whether to have an abortion. The Bill of Rights protects society from corrupt politicians as well, since the same freedoms and requirements apply to everyone equally. Like Madison states in Federalist 51, if men were angels, no government would be necessary. Opposingly, the Bill of Rights erodes the complete sovereignty of legislators. A further weakness of a Bill of Rights is it gives virtually unlimited power to judges to impose subjective interpretations, many of which may be in direct conflict with its original values and intentions. The State Bill of Rights is more specific and tuned to the state's needs. It's important to have both because the National Bill of Rights and the Constitution do not cover issues regarding education or rules applying to the police.
A positive right is a freedom to something, such as free schooling, free healthcare, a job, and a minimum wage. While a negative right is a freedom from something such as freedom of speech, protecting against government restrictions, freedom of religion, protecting against a forced religion, freedom from violence, freedom from slavery, and property rights. Negative rights and positive rights are both found in the Bill of Rights and in amendments of the Constitution. Both of these are equally important in the preservation of liberty. Negative rights protect our ability to speak freely, act freely, and to be free altogether, while positive rights are essential because they allow the citizens to go make a living and to be protected by our government. In order to preserve liberty, we need to be equally protected by our government and from our government. In the past year, we have seen examples of both negative rights, like in the protests for Black Lives Matter, freedom of speech and freedom of assembly were successfully used. And positive rights are seen every election, allowing the citizens to vote their representative in both state and national elections. And that concludes our presentation.
Very good, thank you. Please put your notes away and we'll move into follow-ups. Picking up where Andrew left off, what limits, if any, should be placed on rights that are listed in the Bill of Rights? I believe you mentioned speech and assembly. What limits should there be on those, or are there?
In my opinion, I think there should be limits placed on the Second Amendment, the right to arms, just only if there's someone with a mental disability or has been prosecuted prior in their life.
I would like to go off what Sophie said. I agree that to focus on the Second Amendment, the right to bear arms, it's such a broad aspect when it comes to what it states in the Constitution. Unlike our West Virginia Constitution, it is specifically stated in Article 3, Section 22, how the right to bear arms is for self-defense, for family, and for the state, or for lawfully hunting. So I feel like limitations should be on amendments that are very broad and up for interpretations.
I would like to take what Tamira said about how it's very broad and up to interpretation for our freedom of speech. A lot of citizens could abuse that power by putting down minority groups and justifying their reasoning by saying they are allowed to say as they wish because of the freedom of speech. If there was a successful way to limit that in a term of not being able to use it as a discrimination tool, that would be ideal, but it's very difficult to work around.
Do the courts place any limitations on free speech today?
They do have rules like you can't just call fire in the building and that rule. But it's hard for the government to place restrictions on freedom of speech because like conspiracy theories like QAnon, if you prevent stuff like that, it's hard to say what is what to prevent or not to prevent. So we should prevent those stuff, but it's hard to make restrictions in the broader sense for that.
Thank you.
What is the difference, if any, between rights that are added through the amendment process and rights that are established through a court decision?
That's a good question. I think the rights that have been established later could be interpreted differently than they were prior to when they first created the amendments. So the founding fathers didn't have the same outlook as people today have because their lives were different. But I think it could be interpreted differently now.
Yeah, what Sophie was saying, they didn't have to worry about all the current things that we're worrying about now about, the LGBTQ community discrimination. That wasn't a major thing back when they created our amendments initially. So the Supreme Court really helps relate the previous ideologies to modern day experiences.
And I like to go off what both Andrew and Sophie said. Back then, when the founding fathers were creating these amendments and laws, I feel like the environment was different. They were under certain circumstances and situations that weren't just relevant today, and vice versa. So I feel like current interpretations and current passings of those amendments is going to be totally different than previous.
Over time, which has proven to be more easy to amend, state constitutions or the federal constitution? And once you give me your answer, tell me why you think it is easier with respect to the one you choose.
I think it is state constitutions because the national constitution, you have to have a majority in the legislator vote to amend that. And state constitutions, it's easier um, because the laws are more, the laws are more specific. So it's easier to change like one little aspect about something than in a broader sense to change it.
I would agree with Sophie and say state constitution and all that stuff because it's just on a smaller scale. It's easier with the process, in my opinion, because like she mentioned, the national scale, it's just you have to have the majority vote, 2/3, have to go pass through a bunch of different groups. It's just harder that way.
I also agree that state would be easier. Instantly, I thought of it as like a school. It's a lot easier to change a rule in a classroom than it is to try and change a rule in the entire school because it's a smaller group and it's easier to get agreement with less people, I feel.
What circumstances might cause a person to lose rights that they have gotten under the Bill of Rights or elsewhere in the Constitution?
I would say when they start infringing on other rights is a big one. So on that stance, why do they get to keep their rights when they're taking away other rights and putting them at harm's way?
I agree with Tamara. Also, imprisonment. Not saying people who have gone to jail should lose like all their rights. I think that specific ones, like we said earlier, like the right to bear arms, like should apply in certain cases.
I agree with the imprisonment, and it makes me think of like when you get out of prison, you can go on parole and your rights are limited. You're not allowed to do everything you've done before because you have to prove that you can actually handle not being able to do it. So in a way, your rights are technically taken away from you for a short period of time.
Should felons be allowed to vote?
That is a great question to ask. I would personally say yes, in a way, because at the end of the day, that president that they are going to be voting for represents them in a way. It represents the country that they're living in. So I feel like they should have a say in who represents them, who's calling the shots for them. But yes, I definitely think they should vote.
I agree with Tamara, but I disagree in the fact that I think it should depend on like why they were in prison. Like it should depend on the circumstance, like what their crime was. And but for the majority of people who serve like a shorter sentence, I think they should vote.
I agree with Tamira in how all felons should be able to vote because at the end of the day, like she said, that's still their representative. It's still going to make changes for them in their country, regardless of the crime. Granted, not be like treasonous.
I'd also like to add on, Sophie, thank you for mentioning about how it determines like whether or not they're crime based, like if they murder someone, but if they just sold drugs. I like to also add on to the fact that that would get on to, how are we going to judge these people based on their crime? Like, are we going to judge their self-worth on if they took a life, then they shouldn't be able to vote? Like, I feel like that also raises questions like, how are we going to determine who gets to vote, which felons get to not vote?
9.
Great. Good filibustering at the end there, just telling me what you guys wanted to talk about. I really enjoyed that. Congratulations. Take a deep breath. You're done. What a well-informed group. I'm extremely impressed with how much awareness you have about the issues of the day and your ability to talk about those things persuasively and knowledgeably in the context of this hearing and our historical, the foundations of our government, right? Great initial overview I wanted to return to Roe, which you mentioned in your prepared remarks, as an example of, where we can correct issues where at the state level they're infringing on folks' rights. But then to Judge Murphy's question, most of you expressed confidence in judges' ability to bring us forward and to apply the laws as society modernizes and maybe keep pace with the times. Well, what happens if we have a court that risks taking us backwards? Are those rights as safe as they might be if there was an amendment for them? So would have loved to have gotten into discussion about that if we had time. You did a great job on my first question, giving me some really interesting stuff to chew on with the Second Amendment. But then Andrew, great job listening for my question, because I did ask about free speech. So you came in at the end there and you made sure to hit the question that I asked on the head so that you all were able to show good mastery of the subject. And then Sophie chiming in with fire in a theater case there. That was what I was looking for. So we got there. All in all, I think you did a great job. This is a super nerve-wracking thing to do, and you were very poised. I would say a little bit more of showing us what you know from the text. If you can bring that into your follow-ups, that'll make your answers that much stronger. And if you don't remember the cases, say it's the fire in a theater case, right? Which is effectively what you did. So great job. I'll let my fellow judges give you a little bit more feedback as well.
I agree with what Judge Johnston had said as well. I really enjoyed listening to you. I like the discussion with everybody being equally engaged in it. And unlike a lot of the groups that we see, you offered many of your own personal opinions about each of these issues. And I think that's an important thing to do, and to not be afraid to step up and be able to do that. I really liked, I think it was Andrew who used the analogy as far as whether it's easier to change the state constitution or the United States Constitution. About looking at it, it's easier to change the rule in a classroom than it is to change the rule in the entire school. I thought that was a good way to kind of bring it down to a level that all of us can understand. But I did like the back and forth and the discussion that you had, and I really appreciate that. So thank you.
I echo the comments of my fellow judges. I thought you demonstrated the fact that you have given great thought to this particular question. And I think you have a great understanding with regard to what we've been talking about. The development of penumbral rights, as you talked about with regard to the abortion rights, Roe v. Wade, and the privacy rights as demonstrated by Griswold v. Connecticut. You didn't cite them, but I thought that was interesting. And I like your reference that the Bill of Rights protects against corrupt politicians. And you talked about Federalist Paper 51, in which Madison said, you must first create a government to control the people, and then you must oblige the government to control itself. And I think those are very pertinent comments with regard to this question. And by the way, the fire case is U.S. versus Schenck, S-C-H-E-N-C-K, in which the judge said you cannot falsely shout fire in a crowded theater. And he was talking about freedom of speech because at the time, the issue in the case was speaking out against the draft at a time when we were dealing with World War I. And he obviously said, falsely shouting fire is an improper use of freedom of speech. You did a good job of responding to my question in that the state constitutions have proven more easy to amend than the federal constitution. You should be aware that the federal constitutions have been, or at least have been recommended, constitute 11,597 proposed amendments. Of those, 34 were submitted to the states and 27 were adopted, including the Bill of Rights. On the other hand, in my home state, We've amended our Constitution 166 times. And in the state of Alabama, they've amended their Constitution 948 times. And as one of your comments indicated, you can deal with local issues in your state constitutions that don't require nationwide agreement with regard to the amendment. And the one big difference between state constitutions and federal constitutions is that most states allow something called citizen initiative, meaning that citizens can initiate an amendment and propose it for submission to the people for approval. But I applaud your depth of knowledge that you've developed over your studies. I wish you well in the competition, but let me say that regardless of the competition, what you have gained is knowledge of your country, of your society. Go forth and be productive citizens with what you have learned. I applaud your efforts.
Okay, everybody. Thank you so much. We're going to give you guys a round of applause for a job very well done today. That is going to conclude our hearing. So I'm going to now stop the recording.